Okay. I think it's I think we're good to go.
It hasn't said to start.
Hello, everyone. Thank you for joining us today. On behalf of the Industrial Fabrics Association International, welcome to the webinar, Prototypes, Contracts, and Legal Issues. My name is Magda Ronigan. I am the National Program Manager for IFAI's Makers Division and also today's moderator. The Makers Division supports the stone products industry and any machine operators in the industrial fabrics industry. And as a leading international trade association, IFAI helps our members thrive by providing education, marketplace presence, trade shows, networking opportunities, resources, and recognition. So if you're new to IFAI, we invite you to join our vibrant trade association. Before we get started with the webinar, I'd like to go over a few items so that you know how to participate in today's event. You will have the opportunity to submit text questions to the presenters at the end of the presentation during the Q&A session. You can type in the questions on the control box on the right side of your screen. The webinar is being recorded and will be available to IFAI members in the future in our video library. And a PowerPoint of the webinar is downloadable during the presentation through the control panel on the right side of your screen. So let's begin. Today we have two guests with us who will be co-presenting. And first I'd like to introduce Chad Miller, Director of Contract Manufacturing at American National Manufacturing. Now, Chad began his professional manufacturing career 20 years ago, and in 1997, Chad and his father, Craig Miller Sr., started a contract manufacturing business where Chad was the managing member. In 2010, Chad and his father merged their business with American National Manufacturing, where Chad was named the Director of Contract Manufacturing. And together, they have led the division to record growth with over $3 million in annual sales. So Chad has over 20 years of experience designing, engineering, and manufacturing products in the medical and consumer sleep system field. He works with inflatables, water bladders, foam products in medical and non-medical applications for the aviation, recreation, marine, and safety industries for clients such as Medtronic, 3M, Baxter, and many more. He is an inventor with 2 patent filings, which resulted in his creating an entire line of products designed for preschools, hospital, and other educational facilities under the brand name Happy Child Products. So Chad has been the general manager of Happy Child Products brand since its inception over 6 years ago. He is a board member of Corona Chamber of Commerce and a state legislative action committee member. And in addition, he is certified in OSHA 511 standards for general industry, as well as being a certified instructor for the Red Cross. So thank you for joining us today, Chad. Our second presenter is Michael Ortiz, who is the managing attorney for Ortiz Law. Mr. Ortiz, Michael, is a former United States Marine, and he practices business and intellectual property law in Corona, California. Mr. Ortiz received his law degree from the Sandra Day O'Connor College of Law and also obtained a certificate in law, science, and technology from the Center of Law, Science, and Innovation at Arizona State University. He counsels businesses on how to protect their intellectual property through proper risk management and contracting, and he represents clients in litigation and disputes involving intellectual property infringement. So we're very happy to have our two experts here with us today. And Chad, I'll turn the webinar to you. Thank you so much for providing information and your expertise today.
Well, thank you very much for the kind introduction, Magda, and welcome everyone. We're about to dive into some really substantive information here, and continuing on a little bit to give you a little snapshot picture of my operation, our company. We have 3 facilities here, one in Corona, California, which is our main home base, and then we have Riverside, Missouri, an 80,000 square foot facility for assembly and distribution. And lastly, our most recent facility is in Tecate, Mexico. So we do manufacturing, as well as here in the U.S., down in Mexico as well. And we're going to continue to grow that. Our company does have a very large range of products we do in the both cutting and sewing world. And within that, we really bullet point the medical, consumer, safety, aviation, education, and environmental industries. And you'll see here some automated cutting equipment and one of our 2 of our sewing lines that we have here in Corona, California. We do have a lot of RF welding equipment, radio frequency welding equipment, from small machines up to some of the largest in the country. We have a 175 kilowatt machine, and our bed plate size that we can weld is 120 inch by 93 inch. So we do a lot of very large oversized welding. And moving forward, Michael Ortiz, let him share his experience.
Hello, everybody, and I just want to say it's a pleasure to be part of this presentation, co-presenting with such an accomplished individual. So my practice is focused on business and intellectual property. Essentially, I help people form businesses. I work a lot with startups. So we handle, business formation, structuring deals, and I serve as general counsel for some of these businesses. I work in intellectual property, licensing, and infringement, technology, software, internet law, and with the new blockchain and cryptocurrency fields growing, I counsel clients looking to get into that space. And the sort of antithesis for businesses is having to file for bankruptcy. So I counsel businesses going through that as well.
So we're now going to go ahead and cover the objectives of this webinar today. We're really excited about the content. So when we walk away from this, we hope to learn the types of agreements and contracts that we may see in our manufacturing business. Next, to understand the difference between an agreement and a contract, to understand what intellectual property is, to learn the key elements of non-disclosure agreements, which are very common for me in my business, to be able to identify at what point you need a non-disclosure agreement. You should have resources to help protect yourself, gain more resources for assistance and information. So that being said, we're going to go ahead and dive right into agreements and contracts. So the first on the left, we're going to just define a contract and agreement. There are some subtle differences, but there's an important clarification that we need to understand between the two. So as you see here, a contract is a legally binding agreement between 2 parties, and the terms which the courts have the authority and obligation to enforce. An agreement is a less formal creation of an obligation between 2 parties. And you see beneath that, we have the definition of agreement as it lacks one or more of the essential elements that are required to be present in order to form a valid contract that will be considered legally enforceable by a court of law. And then on the right, there's some bullet point differences between the two, but just to summarize it in the aspect of my world that I live in, a contract is a broader scope for us and typically involves multiple commitments for multiple things. An agreement, as it says here, it outlines the terms of relationship. So for example, I can have an agreement relating to just raw materials for one of my clients, to where there's nothing other than I agree to supply you raw materials, you agree to use it. If you should change your spec to not use it, you have to buy that from me. So it's limited in scope, and that's really the important differences that it has for me. So what I did want to have Michael here to put any other input that he has between the two as well.
Yeah, so as Chad said, contracts are generally, the broad scope. They can be 10, 15, 20 pages long. Your agreements are generally 1 or 2 pages. Chad's example was a great one. The one key thing, because many manufacturers are considered merchants under the Uniform Commercial Code. When you have a contract with somebody and you have sort of a side agreement as to something, if that side agreement touches on some of the terms of the contract, you want to make sure either that you reference the contract or you reference if you're changing the terms. You want to make sure to reference that original contract so that if there's ever a dispute and the court has to look at them, the court can understand that those two, the contract and the agreement, should be read consistent with each other.
So now we're going to talk about what is the purpose of a contract.
So contracts are basically risk management, risk identification, management, and mitigation tools. In general, what I have my clients do, and I work with clients in many different industries, so I really ask them to think of all the possible worst case scenarios that can occur in their relationships with the other parties. So they do that, and then I draft the contract to try to prevent those risks from occurring, to mitigate damages if something does occur, to outline what the parties have to do, what their obligations are. So it's a problem-solving document before the problems occur. What contracts also do is they outline the duties and responsibilities of the parties, which is very important because oftentimes those details that are important get overlooked in a contract, and when an issue comes up, now the parties are forced with trying to have to resolve those issues on their responsibilities without an agreement, and it can just add friction to the relationship. So essentially you want to identify the red line risk issues. What are the things that you absolutely cannot compromise? Maybe it's a health and safety regulation that applies to the product you're manufacturing that has to be satisfied. So you want to think of those things and put them in there. And in your relationship with the other contracting party, oftentimes those risks are balanced between each other. You might take some more of the risk on your side, but maybe they take more of the risk, maybe at the cost of the goods. So it's a balance, and it's an art really to draft a good contract. You also want to use a contract. You also want to look at it as a way to measure the performance of the agreement. You can set milestones. For example, with prototyping, inherently in prototyping, you don't know how you're going to do the finished product until you get there. So you could set milestones. When you're manufacturing goods, large batches of goods, you want to be able to measure the quality of those goods, how many defects per batch, and you want to measure the cost, not just the contractual cost, but maybe if there are disagreements throughout the contract that add to your labor costs, add to your external costs, you want to be able to measure that with those contracts. You want to protect your IP. We'll go over that a little bit later. You want to outline how to modify the terms. Some terms might be modified orally. Other terms you might want to modify only in a writing signed by both parties. And of course, you want to make sure you know what the payment terms are, net 15, net 30, net 60. And you want to provide a dispute resolution process. Contracts really only come up when there's a dispute. A lot of agreements that I have, that I draft, have arbitration clauses. And finally, you want to outline when the contract ends, so when you're free from those duties. And just one thing is, when you have relationships with parties, the contracts may evolve over time after in the course of dealing with the other party.
Okay, so we're going to move on now to, we just hit a lot about contracts and what the purpose of them. What types of agreements or contracts are we going to see? So these are, there are numerous agreements or contracts that will eventually cross your path if you haven't already. Here are some examples of common agreements that I have had in my industry for my company. So as we talked about, non-disclosure agreements are something that are my bread and butter of what I do. Our customers want to protect their product, their drawings, their ideas, and I want to protect how I provide those to them in a real product, because our intellectual property, and we'll get into that later, we know what we know in our factory and how to set things up and how to do things that maybe a competitor doesn't. So non-disclosure agreements are agreements that are intended to protect the disclosing party from sharing protected information. They're required in the event that I wish to file protection rights in the courts. So we have to have that. Some other agreements I've had is finder's fees agreement. If someone knows someone who wants me to make a product for them and they connect me with them and I end up doing business with them, it basically is an outline of a fee structure, a payment structure, just like when you hire an employee and you have a temp labor company searching for the talent for you, there's a fee that should be agreeable between both parties. So that's another one that if I refer someone else or someone refers someone to me, and it's really up to our company. Sometimes things don't fit and I just want to connect a friendly competitor to a potential business that I'm turning down. Typically I don't, I'm not looking for a finder's fee for that. I'm just trying to help somebody out. And then we have manufacturing agreements or contracts. And the reason I put both those in there is sometimes, like my earlier explanation, I might just have a manufacturer agreement that I only do a certain scope of the project, but a contract would look like, okay, a contract now means I have more things involved. I have more commitments that maybe I'm doing a long-term purchase agreement with a supply chain, with part of my supply chain. Maybe a couple of my vendors have a 6-month lead time, and I want to make sure I'm covered on a contract between my customer and myself that outlines and minimizes my exposure to that long term. If I place a 6-month PO, my contract's got to state not only they're going to have to buy the material today, but for the next 6 months, anything I got on PO for me out there. So that's really for me the difference between an agreement and a contract. And of course, the definition here, they're used to establish the professional working relationship between a supplier and a customer. And then dealer agreements. We do have products that we sell through dealer networks, and there are certain things I do and don't do for them. And for certain things, like for example, a warranty, I warranty the product. So these dealer agreements, they establish how that relationship between the manufacturer and the dealer or distributor is going to sell their products. And there's all kinds of things with marketing and trade show samples, floor show samples, and maybe marketing paperwork, photos I might take. So there's a lot of components to a dealer agreement. Material purchase agreement, I touched on that one earlier. We do use those frequently, and as it explains here, it's used when customers needs a specific material for their product, and requires them to pay for any and all materials purchased for their product on their behalf. Should there be any changes, or they discontinue the product or that material, or they uprev something to maybe remove a component that was in there before. So those are all things that we want to ensure that we have in our agreements that we have, so that I'm not putting myself in any kind of potential unnecessary risk that we want to avoid. Great, so we covered all that. So let's move into what is intellectual property.
So there are essentially 5 categories of intellectual property. In your industry, I imagine you'll be dealing mostly with patents and also trade secrets. So patents are new, useful, non-obvious inventions. There are a lot of requirements to obtain a patent. So you generally want to, know whether this thing you're manufacturing, or whether the client wants to obtain a patent, because there's just a lot of there's a lot of red tape before you can get a patent, and you could potentially lose a patent before you get it. And we'll talk about that with non-disclosure agreements. Trade secrets are very important as well, because a lot of these things that are not going to be patented, you still might want to keep them secret to maintain a competitive advantage in the market or the industry. And with trade secrets as well, non-disclosure confidentiality agreements are fundamental to keep those protections. You might also see trademarks and copyrights, for example, in your dealer agreements. Trademarks indicate the source of a good or service, and a copyright is in original artistic work, so maybe photographs that you take. Computer software code is usually protected by copyrights, and publicity rights. Let's say you want to put your face on the advertisement. Well, if somebody wants to use your face for commercial purposes, they need to get a right to use your image. So those are the main IP categories.
So now we're going to move into, I know one of the things we talked about here is protecting your intellectual property, which this slide does a great job displaying. So how do we do that? So non-disclosure agreements are one way that we draw that line in the sand of what is protected. And there are common types or different types with common names, such as an NDA. Some companies call these things non-disclosure agreements, or a confidentiality agreement, or a confidential disclosure agreement. So these are the common names that can be referred to. And what's the definition? So legal contract between at least two parties that outlines confidential material, knowledge, or information that the parties wish to share with one another for certain purposes, but they wish to restrict access to or by third parties. So it's a contract in which the parties agree not to disclose the identified information, which will be, have definitions in there, what's covered by the agreement. An NDA also creates the confidential relationship between the parties to protect any type of confidential and proprietary information or trade secrets. And as I was saying earlier, we have methods of manufacturing. We have certain things on our equipment that allow us to have either a greater degree of quality or more better efficiency, or even the way we engineer our tooling. I might be able to do something in one step that someone else might do in 3 or 4, and that would be considered proprietary. So I wouldn't want someone coming here, taking a picture of that, and then showing it to a competitor saying, hey, I had this company quote me, here's how they do it, could you do it like this? That would be something that would be a problem. That would be sharing what we consider intellectual property. So moving on, there's 3 different types of non-disclosure agreements. One is the unilateral one-ways. These are ones that basically would come to us where they're basically saying that it's one way, they're going to disclose proprietary information to me, and I've got nothing to contribute back. Therefore, they're not expecting for me to expose anything that I wish to protect from them. In general, our company won't sign a unilateral unless they are literally not going to be expecting anything if they provide me a full technical package disclosing all their materials, all of the steps of production that they have. They've got everything figured out, and I'm not providing any intellectual property of my own. Out of all of my contracts that come across my desk, that happens maybe a couple times a year, if that. So it's very rare that we would be entering into a unilateral. The next would be bilateral, where it's mutual NDA. This is, again, where about 90% of my mutual non-disclosures, the non-disclosures we sign are bilateral, also known as mutual. So it's used when both parties believe that they're going to disclose proprietary information. And again, someone might have a product concept, idea, or drawing, but just because you can draw a product doesn't mean you know how to make it. And that's where I come in. I can take what's a dream, a reality, a picture on a napkin drawing, and I can turn it into a product that can be manufactured. Because a lot of times our clients will come to us with something that we can make one of, but when they want to scale it and you want to make this product for production, it's just going to be too difficult, or have too weak of process controls to make the product quality in high volume scale, or there's so much labor in it that it's just going to make the product cost too much to make and make it unaffordable for the market to bear. So that's where that works for us. And then the multilateral, 3-way. So the multilateral non-disclosure agreements used in situations where there's going to be more parties involved. There's 3 or more parties involved that may disclose proprietary information. For example, I have someone, I don't make, we make a lot of consumer mattresses. And one of those things, I don't make the foundations that the mattress sits on. So that's a necessary part of what I make, but I don't make that foundation. So I have to pull in a third party. And a lot of times my clients will want a three-way so that whatever I'm disclosing of their designs or their products go to my vendor, that vendor is not able to share my information or my client's information with anybody else. So they might have a wood supplier, they might have a coil supplier. They're not allowed to share our designs or my customer's designs. So that's where the multilateral comes in. So when do I need them? We can talk about key terms first of the NDA. So why don't I have Michael talk about the key terms of the non-disclosure agreements?
Yeah, so there's a lot of info on this slide, and you guys will have this for your reference. But when looking at NDAs, there are a few things I just want you to keep in mind. They have to be reasonable in scope. Well, actually, first, let me back up. You want to have a purpose in there to give, these contracts are for other people that are not parties of the agreement to look at to determine when there's a dispute, how to resolve the dispute. So you want to give that potential judge or arbitrator context. So you want to put a purpose in there, if it's for manufacturing, if it's for licensing, just to give context. It helps so much when trying to interpret contracts. And like I said, you want it to be reasonable in scope. Unless you're using an NDA to protect a trade secret, the duration of the NDA has to be reasonable. It's average 2 years, could be less, could be more depending on the industry, but the circumstances really dictate. If it's an industry like maybe a pharmaceutical industry, it might be a little longer because the life cycle of the process is a little longer. But a lot of times, if it's just something small, 2 years will work. You also want to make sure to define what is confidential. You can't just say, the parties cannot disclose anything that was spoken of in this meeting, because that's going to cover things that are already in the public domain. They're already public knowledge. So when you try to prohibit people from disclosing things that are already public, well, that makes your contract unreasonable, and a judge is probably going to say at least he's going to limit the scope, or he's going to say this contract is just void. You want to outline how the confidential information could be used. If you guys are in a manufacturing relationship, well, it's obvious that the manufacturer has to use the confidential information in order to manufacture the prototype or product. So you want to outline those things. You want to make sure that in your NDAs, you explicitly say that there's no grant of any rights. There's no licensing rights. There's no IP rights are being granted solely through the NDA. You want to do that in a separate agreement. If let's say it's a business, you want to make sure that person has the authority to bind the business to the NDA. And just general contractual issues is you want to know what law governs the contract. Contracts are governed by state law, so in each state, the laws that apply are different. In California, I'm very familiar with California law. Other states, maybe not so much. So most of my agreements are governed by California law. If you're in a different state, you might have an attorney in that state, so you might want to have your agreement governed by that law. In addition, jurisdiction, which is where disputes are resolved, can be very important if this is an interstate agreement. One party's in California, the other's in New York. If there's a dispute, you want to know which court is going to resolve that dispute. And then non-competition and non-circumvention. In California, non-competition clauses are generally frowned upon, except in very rare circumstances. So in your state, it might not be, however. So NDAs can have non-competition clauses, and non-circumvention clauses are common as well, which is essentially the parties cannot go around each other's backs to communicate with persons, for example, that they met through the relationship. And that's essentially, those are the main things to keep in mind for NDAs.
And then one thing that I would like to mention is the governing law and jurisdiction. I like to always provide just my input, and others might disagree, but I think it makes sense in my non-disclosures, what I usually request when doing one with a client or potential client. I ask that the governing law be written in the non-disclosure agreement to take action in the defending party's local area. So their jurisdiction should be handled wherever the defending party is located. So if I have a client in Florida and he wants to claim something against me, that as he's the plaintiff and myself the defendant, that he would be required to have burden of proof and to come and file that in California where I'm located. That way the financial burden is on him to prove that there's some kind of violation there. So just a recommendation for you.
Yeah, I agree. That's a very reasonable term. So you generally need to have a NDA or some sort of confidential agreement in three key situations. When you're disclosing the invention or trade secret or whatever you want to protect to anybody, that's, you know, even colleagues, you know, in the industry, conferences, any time you're disclosing, actually a conference is probably a bad example, but anytime you're disclosing the information, you want to have an NDA because it's very important to show that you've taken the steps to protect this information. If you don't take the steps to protect the information, the judge is going to say that it's not confidential merely by your conduct. And you know, when you bring other people into your factory, I mean, you don't, every guest you have probably doesn't have to sign an NDA, but you have to be diligent in these things because the NDA puts a duty on you to act reasonably to protect this information. So, you know, outside designers, outside, you know, manufacturers, outside vendors, you want to make sure you're doing the right things to make sure they don't disclose the information if it's confidential as well. And finally, with employees or independent contractors, if they're going to have access to this information, you want to make sure that you're putting steps in place to communicate to them that they can't disclose it and to, you know, obligate them to that confidentiality. So many times trade secrets are lost because no employee confidentiality agreements were put in place. If the employee can tell somebody about it, then that means that there's no confidentiality there. And so the consequences, if the NDAs are breached, of course you can lose the client, you can lose the project, you know, litigation, costly, stressful, anxiety-inducing litigation, and lost revenue. What courts usually do in NDAs, because of the sort of character of an NDA, a court will say that you have to stop doing business. If you have a product that's in violation of some sort of NDA or contractual license, court will say you're enjoined from doing business selling that product. So that can be huge. It'll, you know, the profits that you've already made from that product, if you have violated the NDA, will have to be disgorged, which means those profits are now paid to the other party. And then there are many consequential incidental damages that arise. Essentially, you know, unless your NDA is tight and limits these things, you can pay for the lost profits of the other person as well. You know, damages can be very large in these types of breaches. And finally, if somebody doesn't want to sign an NDA, you have to consider the risk. It's not a red flag, but that's a flag. It may be an indication that there's going to be a potential conflict of interest. They might already be working with somebody in the same market or industry, or so you got to just keep in mind that it might be a potential conflict of interest there. You also have to know the culture. With startups or people seeking venture capital, those investors rarely sign NDAs because they deal with so many businesses and so many inventors, and that if they signed an NDA, it would expose them to a lot of risk of getting sued. Anybody who's been sued knows that you don't need very much evidence to file a lawsuit, and all you need is a lawsuit to be filed, and you're out tens if not hundreds of $1,000s just dealing with the court case, hiring lawyers. So you have to know the culture, and ultimately, if you need to narrow the information you disclose, you should do that if it means getting that investment or venture capital. And along the same lines, you shouldn't sign an NDA, one, if it's unreasonable, if you have a conflict of interest, because you don't want to expose yourself to that liability, and just things like that. Because like I said, an NDA places a duty on you to act reasonably to protect that information.
And then one thing too, I think it's important to notice, the person that signs the NDA is only one party that's involved. We can't forget that when I encumber my company to an agreement, a non-disclosure agreement, that there are other people. I might have a drawing that I give to my purchasing manager that he might send out to 3 or 4 suppliers. And some of those suppliers may supply products or materials to a competitor who the damages could be great if they saw something that they knew it wasn't under non-disclosure. So I have to have some due diligence on myself, so that all of my team members, those parties who will be involved, any touch point that requires someone to be involved in a project, it's my responsibility to ensure that those materials that are confidential are stamped or identified as such. It could be an email and the subject could say confidential. It could be a drawing that's stamped with that, but that means that there's something that I must do in order to be compliant with that. And it's my duty to share that with those and my organization. Well, we've talked a lot about non-disclosure agreements. So we might be thinking, well, where can I get a non-disclosure agreement? If you don't already have them, or you do have them that you've got, off the internet somewhere, so don't rely on samples that you find online. I recommend you hire an attorney to prepare one specifically for your business needs, because having an attorney know your operation and know what you do and what you provide, whether it be all your services or the way you do things, they would have a better idea of how to structure it so that you would have a better net around what it is that you're providing to this relationship. And again, I always recommend mutual non-disclosures, because a lot of times customers might think that they know it all or how to do it all, but you've got something that you figured out. I mean, you're in business still today because you are beating out somebody else. So you're doing a better job than someone else. So don't sell yourself short. Realize that you provide value to that relationship, and you should spend the money, a little bit of money, to protect it. So that being said, now I know where to get it. How much could they cost? What do I expect? Well, a basic NDA shouldn't cost more than about $500. But of course, depending on specifics or your industry or kind of what you're doing, if it may be something, it has to be something further or deeper, it could cost up to $1,000. But just have an attorney look at it and have them give you a quote. It's usually free to have a quote for something like that. But nonetheless, it's cheaper to have that, in place, a proper one, because you could really incur a lot greater costs if you don't have a good one, like paying a lawyer if there's a lawsuit that's got to be filed, whether it's someone against you or you against them. So just more recommendations from that. So now we'll talk about all this protection, all this stuff is all legal issues that we're trying to head off, avoid, or have things in place so that we can really reduce that kind of risk. So some of the legal issues we're going to talk about: intellectual property. So we talked about that already. Whether it's document control, you have IT, information technology. You've probably seen in the news lately a lot of breach of data. I collect payments, I collect information that is considered to be protectable. I have employee social security numbers. I have credit card information and payments. We do have stuff on the cloud. We have confidential information that's stored there. So there's a lot of risk there as well. And then of course product. You've got product design. You've got quality and marketing and the actual product that can be used or misused. And there could be legal issues related to that. International. There's all kinds of, when you get into selling or buying raw materials or goods and moving it across borders, there's for example, the NAFTA you've got to follow. There's certain requirements for certain countries that you can or can't export or import certain goods. There's certain fees and duties and tariffs. So having the appropriate things in place, having someone that's knowledgeable in handling all those things of the right commodity, the HTS code, for the right commodity crossing the border. And so there's a lot of things that you could get yourself into legal issues with if you didn't have the right information or you didn't do it correctly. Then there's just overall business like regulatory compliances. We live in California, which is very highly regulated. I can't make a product and then sell it to California without certain things happening. I got to have a Prop 65 label for things that qualify. You have to know what qualifies. So there's a lot of burden on myself to have a connection with regulatory changes, legislative changes, and know what kind of insurances I need to get. Insurance, like literally financial insurance of a product liability, business insurance, moving goods. Maybe I'm insuring a product that I'm having raw material shipped for a customer overseas. Who is paying once it leaves the factory? Who's covering the insurance of it leaving their dock or their door to the dock, to the boat across the ocean, to the port here, onto a truck, to my door? All those things are part of what I need to make sure I'm covered on my business side. And then of course, there's always HR. If you have employees, there's always health issues, safety issues. You got to make sure your employees are trained. They can't be going up on a forklift without fall protection if it's a picker. So there's all these requirements. And a lot of times I've got a lot of larger clients who have me sign human trafficking clauses saying that I'm abiding by and my supply chain are abiding by these laws of human trafficking, what I'm doing, ensuring I have a program to require that of them. So there's a lot of things that expose myself to legal issues. And so these are just 6 major bullet points. I don't know, Michael, if you'd like to comment on any of these.
I think for me, aside from protecting IP, regarding products, in general, so in product defect law differs by state, but in general, all sort of people in that line from manufacturer to sale are liable for defective products. So just keep that in mind. If you're involved in a product that you foresee might create some injury risk, maybe it's a defective design or there's a potential defect in the manufacturing, just be aware of that. And you could limit your liability in some ways. And then finally, with human resources, wage and hour claims are absolutely just a nightmare for large businesses. So put time and effort into making sure you have systems in place to not only have your employees follow the law, but if something happens, let's say an employee misses a meal period or a rest period or works overtime, know what to do in those situations. Whether in California you have to pay an extra hour's wage for that day. So even if there are violations, you can still remedy those violations, but just that is one of the biggest killers for my clients, for businesses.
Great point, really great point. So I know we've covered a lot, and I know we've only got about 15 minutes left. So let's go ahead and move right into our tips. I always like to provide tips on these things. So keep your intellectual property to yourself, and if you have to share it, we talked about that. Ensure that you've got your intellectual property protected properly there. And then number 2, conduct a patent search before investing too much time or money into a project until there isn't prior art. To allocate resources is it's just unwise when you know it can't go anywhere. And a lot of times I really have a hard time. My customers don't realize what kind of time it takes to go through read patents to find out if their concept is too closely representative of something that already exists out there. So that's kind of something that's an overhead that you've got to take on, but know that a product that's kind of a gray area, maybe you should push it back on them. You know what? Give me from your attorney, why don't you give me a letter stating that you believe that he believes there is no conflict.
Yeah, and I'd say as far as, so you could do a patent search yourself, either through the USPTO website, or you can go to most university libraries, can help you with patent searches. If a lawyer is going to do it, it'll probably cost maybe $2,000 approximately, maybe $2,000 to $4,000 for them to do a full patent search. Depending, you know, some industries and inventions have more inventions than other industries. So they're essentially, if they can't find it after 4, 8, 10 hours, then it's the returns are going to diminish. So it should only cost about $2,000 to $4,000.
Excellent, great point. And another recommendation, another part of the 10 tips. Number 3 here is sign and date all documents relating to product R&D, because that establishes the date, the beginning date of when you were starting to work on that. So, and that's really key down the road. Number 4, join an industry association. I know we are members of the Industrial Fabric Association. They provide us tremendous direction, tremendous help, information, supply chain, and webinars such as this. They're there to help. And so there's a lot of knowledge to be had and a lot of connections to be made through an industry association such as the IFAI. And then number 5, register for different association or industry trainings. There's a lot of them out there. We have an annual conference. I know I go and I exhibit, and there's a great wealth of knowledge and campfire trainings and training sessions that you can get into and attain certifications so that you are certified. And I know that your potential customers really like the fact that you put effort into being knowledgeable of not just what you know today, but what's coming down the pipeline. And then number 6, hire an attorney to create you a mutual NDA. We hit that one earlier, and I want to make sure it was on one of the top 10 tips. Number 7, protect yourself from financing your customers' R&D. One of the things that in previous webinars I've stated prior is, if my customer isn't willing to invest in the development of their product, why should I be? And I should never be more than they are. So kind of use that as a measurement or tool gauge that you can use of really how much are they willing to invest in their own product. Because remember, you're probably going to be signing that you have no rights to it at all. So keep that in mind. Number 8, develop a relationship with a lender in your industry. I know us we many times wanted to buy a large piece of equipment, or we entered into an agreement or a contract with a client who I had to have specialty equipment. Many times, I can work with, if I don't want to capitalize that myself, work with someone in my industry that understands my process. We have one specifically that's very familiar with the plastics industry, and they work with us if we want to have a high dollar item and maybe a $200,000 or $300,000 piece of equipment, or I need to expand my building or do improvements on my building. It's good to have a relationship with someone that knows who you are, and things seem to be done much quicker and easier for you. Number 9, hire someone with expertise. If I'm making something in the education industry and I currently don't know that, having someone alongside you, whether it's a consultant or having send someone to those kind of trainings, as we mentioned earlier, it's always great, because you got to remember that you don't want to be in a position where your ignorance of something is not an excuse. So knowing what you're getting into before you get into it is definitely a tip I recommend. And then number 10, the best patent attorneys, they're credentialed engineers and they know your industry. So we have a patent attorney we've used for many, many years. He unfortunately passed away recently, and he knew about sleep systems. He knew about inflatables. He knew about how you could protect a product, not just how it functions, but maybe the way it attaches to something else. And so he had a degree in engineering, and he knew our products, he knew our industry, and he knew things that he could do to throw a bigger net when he wrote our patents for us. When he put the verbiage in the claims that were made, he did such a great job. So there's probably some things that you could do when you ask questions of an attorney firm and you're looking for the patent attorney, that you might want to have a list of questions that, that if their answers were right, that you would say, hey, this is the right attorney for me. So know that there are a lot of patent attorneys out there. You got to find the right one for you. And the one that I use may be different. Maybe you're an installer, maybe you fabricate sails or shades that go onto buildings. That might be not the right fit for you. My attorney might not be the right fit for you. So not all of them are created equal. I guess they have specialties, and I think there's a good idea to do some questions with them and interview them to see if they're the right fit for you. Great. So now we want you to walk away with some resources. So we can leave you with a few here. We talked about doing patent searches. So this right here is the United States Patent and Trade Office's website. You see there at the top left the link, the uspto.gov, and this is a screenshot of them, and they make it really easy to search for things. And you can see kind of here the patents and trademarks columns and your quick buttons that you could grab. I know I work on this a lot, and Michael, you may as well.
Yeah, it's very user friendly, and they write things as best they can in plain English. So it's a great resource.
So feel free to browse around that. The next resource we have is I have been on the National Association of Manufacturers, the NAM, and it's NAM.org. You can see on the left here on your screen, their priorities are litigation, education, and resources. And we've covered a lot of that today. You can dive deeper into it by navigating to that website, and then you can click specifically onto one of those areas. And on the right of your screen, you're going to see kind of a screenshot of what their entry of their when you click on the Center for Legal Action, you'll see it specifically for manufacturers. So once you get to the NAM.org, you're going to look for the Center for Legal Action, and that's the actual page there. And you'll see they've got areas of environmental and energy, they got labor and employment areas, product and civil liability, international trade, which we touched on, intellectual property we talked about, corporate governance and shareholder liability. And then at the bottom, you'll see a link there to a click to the legal toolkit and resources. So I recommend you go on there and spend some time browsing around. A great resource, to kind of go deeper into this webinar. Great resource for you there. Excellent. Well, I know we only got a few minutes left, and I wanted to make sure we leave enough time for any kind of questions that any attendees would like to ask.
Well, thank you, gentlemen. Really useful information. And if you're watching right now, you can type in any questions that you may have into the control box on the right side of your screen, and we'll have time for just taking a few questions. We can see, Chad and Michael, from the breadth of the experience, information that you've provided, how important it is to work with somebody who really has a depth of experience and can predict a lot of the circumstances that might come up when dealing with manufacturing process. Would you be willing to provide a couple of items that maybe surprised you when you're working with contracts about what to include, situations in the manufacturing process, maybe working with distributors or suppliers that you had to learn the hard way, or that you wish you had known earlier in your career?
Yeah, I certainly have many examples. I'll try and keep this one short. A lot of times we allow our customers to supply us raw materials. And my ability to RF weld those materials are really predicated on the formulation of those materials. So if one of your clients makes a change without you being notified, and all of a sudden you're receiving 5,000 pounds of material, and all of a sudden your process no longer works as it always has, what's in the agreement to have remedy for that? So we've been surprised that a fire retardant chemistry was added to a plastic, and my RF machines were unable to weld it. So I'm spending all this time, or maybe it increased my labor or machine cycle time by 30 or 40%. I got to go back and charge my customer for that, because what they are now supplying me is actually different. So that being said, there's been surprises like that, where when you allow them to be part of the supply chain process, having something in place that puts the responsibility and liability back on them, that if that should happen, you've got yourself covered. So we have had surprises like that.
Yeah, and I saw we did get a question, but for me, two things that I just always have to reiterate is making sure the parties understand the specifics. And there's one case that I always bring up, and it's an old case that we studied in law school. And these parties, it was a chicken supplier, you know, a farm and I guess a retailer or something. And the contract said that, you know, one party had to supply chickens, but they're just, little did I know, there were multiple different types of chickens. There's fowl, there's different types of chickens. So one party supplied one type of chicken, the other party didn't. It wasn't the right type of chicken. And then they went to court, and that case went through appeals court and everything. So it's really important to be clear as to what the product is, what the duties are, because you know the industry best. So you should. So that's why I said try to think of all these miscommunications, these differences in understanding, and try to remediate those. Another thing I see is that when there are joint investors or joint inventors, or one's an inventor, the other's a sort of doing the funding, you really want to pin down the ownership. Generally you'll create a business entity, and each party will have a equity interest in the business entity. But what about licensing profits? What about so when you have partners, when they're even if you're a manufacturer, and to offset the cost, maybe you take some equity in the company, or a license of the IP. So those things they're always complex, and they always keep me on my toes. But yeah, and then Magda, if you want me to answer this other question as well.
Yes, why don't you go ahead? Thank you. State the question first, please.
Okay, it says, what percentage of time do you insist on using your NDA versus spending time and money negotiating your customer's NDA? If you hire an attorney to draft an NDA for you, generally that's the biggest time expense in time and money. After you have that initial NDA, you could probably you could just recycle it. You can change the parties. Keep in mind that different contexts, different scopes might affect that, but each deal is different, in size and sort of and risk. So, but you generally don't have to spend too much time on it after you get the initial NDA.
Yeah, and for me, I get about 10 to 15 RFQs a week. And of course, every single one has their own version of a non-disclosure they want me to look at. And I could go broke trying to have someone read through all that, determine the differences. So what I do is I use a couple of basically tact when I'm talking to them. They'll send me theirs, and I'll reply with, I'm sorry, our company has a professional NDA prepared for our industry. It's a mutual non-disclosure. It's attached. Please review it. And if it's unacceptable, please let me know why. So what I do is I almost don't even offer to even look at theirs. I just reply back with, here's the one that we have been using for 25 years. And yes, we have modified it slightly because of one minor thing, but 99% of the time, 99% of it is acceptable. And there might just be one small thing to change, and we can change that in-house. And our attorney most of the time will look at it and go, yeah, it's fine, or oh, I'm okay with that. It's just an email. Hey, they want to change section 5.2. Is that an issue? Reply back, and usually they're okay with it. So to answer that question more directly, I like to force them to use ours. I won't spend much time. And if they do really push on that, I'll tell them, well, look, we can move forward. I don't need to know specifics. You can tell me length, width, height, dimension, what materials, because if they're not willing to use yours, that means that they don't want any proprietary information from you. And so I won't share anything. You could provide me with whatever, great. And I mean, the worst thing you can do is you, like, if you are interested in the project, look at theirs. if they're really, really pushing you, and don't provide any information. Get the drawings, look at it and say, thank you, no, thank you, not interested, or yes, it's up my alley, but I don't have enough. I really want to use my non-disclosure. And now you cancel the other one and use yours. But at least it allows you to look at their product and know that, hey, look, I wouldn't go any further unless you get your mutual in there yourself.
Sounds great. Thank you, Chad. So if a company that you rep turns out to be impinging on a patent, what liability does the rep incur?
So it's similar to the NDA liability. If they're infringing on a patent, generally they're manufacturing this invention and either trying to commercialize it or already commercializing it. So generally you get an injunction to prevent them from doing whatever it is they're doing, and they're not easy to get. There's a lot of legal costs up front because you're essentially having a mini trial in the beginning of the case. Well, first you want to send them a cease and desist letter. Generally that doesn't work, and then you have your attorney file a lawsuit, file a complaint, and then try to get an injunction. So the injunction will stop. It's a court order to halt that business practice, and then damages are, if the invention was already commercialized, whatever profits that infringer has made are going to be disgorged, or that amount is then going to be owed to the plaintiff, and then whatever the plaintiff's lost profits are, that could be awarded as well. If it's a sort of a malicious case, then there can be multiples of the damages amount. So if it's really bad, maybe the value of the lost profits and the profits of the infringer are $1 million, while the punitive damages or statutory damages might be $3 million. So it depends on the situation, but I mean, patent litigation is very expensive, which is why you want to just cut this off at the head and protect your IP from getting getting discovered or infringed on by those NDAs, by those confidentiality agreements.
Thank you, Michael. We have just a little bit of time left. We're actually over just a little bit, but I'm going to combine the last two questions. And they're regarding NDAs. So if when in the NDA process, do you consider announcing that the information is proprietary? I mean, can you just proclaim that what is being discussed is proprietary, and does that hold any legal weight? And then secondly, with a valid NDA, does the company that you're working with have to sign it in order for it to be valid?
So generally, you want the NDA to be, signed by all the parties at the beginning of the relationship. An oral sort of proclamation of confidentiality is just not going to work. That's not, it's a reasonable. There's a reasonableness standard here. It's unreasonable for you to expect somebody to keep something confidential solely based on your oral proclamation to keep it confidential. So you have to have a signed writing. And yeah, so if it's a company, you want to have somebody with authority to bind the company, or you want to have, that person. So as part of the NDA, you would have a clause that says, so-and-so has authority or represents that they have authority to bind this company. So what that does is, even if the company didn't give them authority, they represented to you, so you in good faith relied on that, so you can still obligate that company to the NDA.
Well, thank you very much, gentlemen, for this valuable information. I know our viewing audience really appreciates your expertise and your willingness to share it with them, which is one of the things that makes IFAI so great and valuable to our members. We appreciate everybody joining us today. And as a final note, the webinar will be loaded up onto the IFAI's Makers Division website should you want to revisit it at another time. And as long as you're an IFAI member, you can access that webinar through the website at your convenience. So thank you very much for joining everybody today. We really appreciate your being with us. And thanks again, Chad and Michael.
Thank you.
Thank you.